things. Today's presentation, we're really excited to have Heather White here. Heather is an attorney with Christensen and Martineau, great law firm here in the state of Utah, and she does a lot of defense work for the trust here. She focuses on the defense of governmental clients and really focuses in those high profile civil rights cases. And so we're happy to have Heather here today to talk to us about discretionary function immunity. Heather, do you want to go ahead and take the screen?
Okay, excellent. Thank you so much for having me here today. It's really good to be with you guys. It has been a while. It's been a while. My brother flew out of the airport today for his first conference. He used to go to a lot of conferences around the country, and he was so excited today to get back on the plane for the first time and go back to some conferences. So with the sun out and the weather nice and starting to get back out with people, it makes such a difference. And I appreciate all of you and the opportunity that I have to get to work with you. What we wanted to talk today a little bit about is discretionary function immunity. We've had some cases over the years where there might have been a possibility of raising discretionary function immunity as a defense, but the courts require very specific record keeping and procedural hoops to jump through before it will apply discretionary function immunity. So the trust wisely had noticed that there was this need and opportunity for us to formulate a plan ahead of time as to what needs to be done for government entities to have the evidence in place necessary to implement a discretionary function immunity defense in the event that it becomes necessary. So that's what we're going to do today. We're going to walk through a little bit about what it is, what the courts have held, and then practical things that you can do as with your governmental entity to help set up the defense in the event that something occurs. So with that, let's just get started. As you are aware, the Governmental Immunity Act waives immunity from suit against governmental entities for injuries that are proximately caused by a negligent act or omission of an employee committed within the scope of employment, with certain defined exceptions. And one of those exceptions is the discretionary function exception. It retains governmental immunity if an injury, quote, arises out of the exercise or performance of the failure to exercise or perform a discretionary function, whether or not the discretion is abused. And that exception is found in Utah Code Annotated 63G-7-301, subsection 2I. So in applying that, it's important to understand what is a discretionary function and when can it apply and how do we make it apply. So starting with that, I want to back up with the purpose of discretionary function. And that is, it was intended to shield government acts and decisions that have an impact on large numbers of people in a myriad of unforeseeable ways, from individual and class legal actions, the continual threat of which would make public administration all but impossible. That's a quote from our Utah Supreme Court from a case back in 1990, walking through what the purpose was as they were going to define what exactly a discretionary function is. So that is how they define it. And then moving forward, how do they go forth and apply it? The Utah Supreme Court has explained that almost every action of a government employee involves the use of some type of discretion. And so it has narrowly applied discretionary function immunity because it has concluded that discretionary immunity was not designed to cloak, as it says, I'll give you a quote, cloak the ancient doctrine of sovereign immunity in modern garb, or in plain language, it wasn't a rule that was meant to swallow the whole. So accordingly, it has narrowly construed discretionary function, and the exception must not include determinations that are made at the operational level of decision making. And that rule was set forth in the Carroll case, which you'll see on your screen. Discretionary function immunity is a very fact-intensive operation. Any decision that does not require the exercise of basic policy evaluation, judgment, and expertise is not discretionary, but it is operational. And the Supreme Court has held those types of decisions, those operational decisions, are not protected. And by the same token, it is also held that decisions that merely implement the detail of an already decided project do not qualify for discretionary function immunity either. So let's talk a little bit about that and the cases and how they've interpreted that language, the purpose and the definition of discretionary function. One example is the Utah Supreme Court has found that a city could not invoke discretionary function immunity in a case that involved a pedestrian who tripped on an uneven sidewalk. The court ruled that even though that sidewalk maintenance does require the allocation of scarce public funds, the court emphasized that discretionary function immunity may not be interpreted to create a blanket immunity for governmental negligence in every case where the government saves money. So just because the city sidewalk maintenance policies permitted a wide range of discretion to the Public Works Department about how to respond to public or to defects in the sidewalks. The fact that it left the maintenance decisions and categorizations to the decision of an employee to judge how to categorize those and respond to any defects meant that the decision by the city employee was not directly a classic operational determination, and that such decisions do not qualify for discretionary function immunity. And let me read you just a little quote about what the court said. It said, the decision by a city employee not to directly remedy the sidewalk defect for whatever, and this is outside of the quote, for whatever reason may be, whether it's limited funds, manpower, it doesn't fit into the timing or an operational program. Okay, going back to the quote, the decision by a city employee not to directly remedy the sidewalk defect is a classic operational determination. That is a decision implementing the existing sidewalk maintenance policy. And so because that decision was merely an implementation by an employee of a prior policy decision, it did not qualify for discretionary immunity. So it's really difficult for us to be able to argue that a trip and fall on a sidewalk or that a defect in such as a pothole, or where there are overlays on a street and you have margins of of levels that, you know, down into a water hole that a biker might hit and cause them to fall. Those types of decisions really do not qualify for discretionary function immunity, and we won't run those types of motions because we know that they won't be granted. Let's go and talk now a little bit about when the court has found that discretionary function immunity applies. There was a case back in 1989 called Rocky Mountain Thrift Stores, Inc. versus Salt Lake City Corp. And it addressed the design of the City Creek drainage system. And in that case, the Utah Supreme Court found that discretionary function immunity did apply. And that is because the issue in that case related to the design, capacity, and construction of a flood control system. The court explained that because of the important geological, environmental, financial, and urban planning and developmental concerns that all were wrapped up into the design of this flood control system, that discretionary function immunity applied. And it ruled that that was the case, even if the city knew the system was inadequate to handle a severe 1 in 100-year flood, because it would involve policy evaluation, judgment, and expertise to determine what changes or improvements should be made at public expense to manage a flood that might never occur. And so you're seeing the distinction between fixing something that, you know, is something that just any old important employee can do, and one that requires studies. It involves environmental concerns. It involves how resources that are dedicated, financial resources that are dedicated to creating something that doesn't already exist, and how that project will have an impact on the community. So you can see that there's a difference in how that applies. So going on to additional cases, there have been several where the court has determined that discretionary function doesn't apply because the decision is an operational decision. And I want to just go through and highlight what those are for you so that you can kind of key into maybe things that you don't need to be focusing in on as much. And then we'll talk about the things where you do want to be focusing. The following types of decisions have been ruled by the court to be operational decisions. Installing a dirt beam instead of a sign at a highway curve to prevent traffic from going off in a certain way. Treatment decisions made by a physician. Now that may sound odd, but we do have the University of Utah Hospital, which is a governmental, I believe is subject to governmental immunity issues. We also have, and remember this, paramedics and EMTs that are providing treatment decisions on emergency medical services. And so in addition to the immunity that is already provided under the Governmental Immunity Act for the provision of emergency medical services, there's the second layer of protection of treatment decisions that are actually made. So I think an EMT and a paramedic and any type of employee that provides those type of treatment decisions responding to a call for emergency medical assistance would likely fall within that category as well. Another one is whether or not a child, and under what circumstances a child should be removed from their home and placed in foster care. This is an interesting one, whether the governmental entity could sell an impounded motorcycle. That was an operational decision. And dredging a particular stretch of creek to assist with runoff water management is an operational decision. So that's different from the flood control, right? Because that's merely the implementation of when do we go out and scoop out the bottom of the creek and get rid of the debris, remove trees and leaves that have fallen, versus installing a system. You know, where do we do it? How do we do it? What types of property is it going to impact? So those things are likely do not qualify for the discretionary function immunity. More examples of operational decisions, and you can see by the large number of cases that have addressed this, the court has shot down discretionary function in a large majority of the cases that it has provided. So it's not a common defense that we're able to assert. Additional ones have been suggested or held to be merely operational decisions, such as monitoring an individual on probation, where to put to place a traffic control signal, whether to use cones or barrels or barricades or any other type of traffic control device on a project for traffic control. And then prioritization of those routine types of sidewalk maintenance and repair issues, such as grinding down ledges in a sidewalk, or removing and replacing, or painting those on there. So those are operational decisions which do not qualify, as well as a fence repair. Some other things that where we've had cases, I'm just thinking of one now, was probably whether to trim a tree and when to trim a tree so it doesn't block a stop sign. That we had a case like that, and that would not qualify for discretionary function immunity. So you can see there's a broad swath of decisions that say it doesn't. So let's talk a little bit about when it does apply. Where has the court held that it would apply? And one of the interesting things to note is there was, back before, I would say, the 90s, in the 1990s, there was more of a chance of obtaining a decision that discretionary function immunity applied. And then we had a shift in court members and a culture on the Supreme Court that persisted for, I would say, about 20 years, that really changed things and made it much more difficult to apply discretionary function immunity. I would say about 5 to 7 years ago, we have had another culture shift on the Utah Supreme Court, where immunities are regaining strength. And so it is difficult sometimes to predict whether something that will apply. But I think that the time now is more of a chance that we would be able to obtain a ruling that discretionary function immunity applied than there would have been during that time period where they were very reticent. And the cases that come out of the court signaling discretionary function tended to be more in the arena of the era that we're talking about, where there was that culture that was more favorable to discretionary function immunity. So examples of cases in which the court has ruled discretionary function immunity applied are what we just talked about in the Rocky Mountain thrift store case, was the design, capacity, and construction of flood control systems. Another one is the placement of safety devices at railroad crossings. Now, the important thing to remember about that is governmental entities do not have a duty to install safety devices, lights, traffic control signals. But when they do, they undertake a duty to ensure that it is maintained. And failure to maintain that results in that negligent carve out to governmental immunity that allows plaintiffs to sue. And maintenance with respect to those fall under the operational decisions. However, whether to install a light at an intersection or a crosswalk at a certain point in the road, or put in arms that come down at a railroad crossing versus just a sign maybe and some lights. Those are the types of the placement that would qualify for discretionary function immunity. And we have several cases that address that at railroad crossings, which we've used to analogize to other types of situations such as lights, crosswalks, crossing signals. Another one, these are a little more very rare circumstances that would occur, but it gives you a flavor of what the court sort of is looking at in deciding that immunity applies. Adopting an ordinance that required servers in a restaurant to submit to annual screenings for diseases, determining whether a child should be placed into foster care. And that is an interesting one because, as you recall, when we went back to our other case, there was a case that addressed that might not apply. So if it's a routine sort of decision that applies, discretionary function immunity wouldn't apply. But I think if it's the target is a policy and how that occurs, then you're going to be looking at a different sort of analysis and possible discretionary immunity. I think you're getting what I'm saying is it's really going back to those terms, evaluation of policy judgments, expertise, community impacts. Those are the types of things. And then the city's determination not to bury power lines at an airport, where the city had specifically sought a quote to bury power lines, but then determined the amount was outside the airport's budget. That was determined to be a discretionary decision. There are some more that we have that are a little bit narrower. Issuing a permit, allowing a server in a food industry to work. The creation and implementation, well, I would say implementation would be likely non-discretionary. Creation of a program by which prisoners are let out to do work release tasks. Again, creation of that would be a discretionary function, but anything that happened, for example, if the prisoner was injured while performing the work pursuant to police prison program because they weren't provided with a safety vest and a car hit them, that would more likely be an operational decision that would not qualify. And then also determining whether a particular prisoner has displayed the aptitude, the character, and likelihood of rehabilitation sufficient to qualify for work release would fall under a discretionary function, as well as granting someone probation from prison. So those are the types of, I mean, you can see why granting someone probation would apply, because there's necessarily the expertise required of maybe a psychologist or a psychiatrist, of behavioral aspects, data analysis, and that goes along with that. So those would be discretionary. And then there are cases which there have not necessarily been held to be a discretionary decision, but have been suggested. So some of these might be in the suggested case, whether or not to embark upon a particular road maintenance project. For example, we recently had a case where there was an allegation that the city should have installed a sidewalk on a road that that used to be county. It was, before it was in the city, it was county owned, and in the neighborhood, as in my neighborhood, there are places where there's sidewalks, and then there are no sidewalks, and then there are sidewalks. And we explained to the plaintiff's counsel in that case that discretionary function immunity would apply to that, because the city had considered at great length requests to put that prior requests to put in the sidewalk, and all throughout the city, and where those needed to be prioritized, and how they worked in with other urban planning issues, how they worked into the city's budget and the need to provide for other areas. And so those are, you know, whether to install a sidewalk or similar to a sign or traffic control devices would be a discretionary function. UDOT's decision to not install a concrete barrier that would need to be entirely replaced when the road was resurfaced a few years later, and would have cost a great deal more of money and caused significant disruption in traffic, was concluded to be a discretionary function, as opposed to just, do we put out barrels or cones? Because there was that weighing of factors as to, you know, we're redoing this road. Do we want to go to this great expense of installing something that's permanent, just tear it down in a few years? And then the height of power lines and type of insulation used on a citywide basis. So those have been suggested or determined to be discretionary decisions. And there is, even though we have had a shift back to allowing more discretionary function, there are fewer decisions. The trend has been fewer decisions applying that immunity than there were many years ago. I maintain that one of the reasons for that is that the municipalities have not had the backup information that they need to implement the defenses. And so that's one of the things that we want to provide for you here today is, you know, what do you do to give yourself the best chance of having this apply? So I want to talk about the considerations that you're going to be looking at. Who is making the decision? Is it someone, an employee who is tasked with day-to-day operations, or is it that policy? If a governmental entity wants to have a decision protected by discretionary function immunity, that is one of the considerations that will be very helpful is in assessing is who is making that decision. And there are a couple other factors I just want to point out at first. None of the factors alone will be enough to transform this fundamentally operational decision into a discretionary one, but they might be enough to tip the scales in a case. And because they are so highly independence and turn on the evidence, the guidance that we're going to provide will help you generate documents and paper trails and witnesses as to what you need to do to retain that immunity, to bolster the claim for immunity. So first, to the extent possible, the decisions should be made by elected officials rather than hired employees. Now, does that mean that having an elected official, the mayor, just decide when sidewalk maintenance is going to occur, is going to transfer that to out of an operational decision into discretionary function? No. As I stated, it doesn't necessarily do that. But you saw in that UDOT case where they decided to install the concrete barriers, temporary ones instead of permanent ones, you can see how that might have been resolved under a operational decision, but with the proof of the planning and the decisions about why it did what it did, it was enough to just get it over the hump to qualify for discretionary function immunity. So although it's not determinative, elected officials are generally assumed to be acting in accordance with broader policy considerations, city councils, county councils, mayors, in those various entities. And there's discussion and public discourse that surrounds those types of decisions, whereas it's not just an implementation of a program. A department head who is aware that numerous repairs are needed to alleviate potentially dangerous conditions, they may want to expressly include a request for all the repairs in a budgetary proposal, or at least in an alternative, even if they know that they won't be able for that entity to fund all of the repairs during the next fiscal year. And so to have that consideration that the city council or the county council or the governing boards of whatever governmental entity of the service district considered these various things and then pass that along to the department head may be able to tip the scale in the case. And in addition to practical considerations that might weigh against that, it's important to keep in mind that for immunity to apply, the decision has to be made by an individual, a body, or an agency, and this is a quote from the Supreme Court, quote, with the requisite constitutional, statutory, or lawful authority or duty to do so or make a challenged act, omission, or decision. So it's crucial that whoever is making that determination be one that has the authority to do that. For example, it varies from different entities who has the decision to make policy for a police department. Is it the police chief? Does the police chief make a recommendation to the city council? And the city council has to vote on it with a recommendation from the chief? Is it the mayor? So it's important to make sure to check those things ahead of time and determine what that is. Sorry, I got deep into discussion. I didn't move through those PowerPoint bullets. Moving on to the second consideration is that the governmental entity should be able to make this is a quote from the Supreme Court, make a showing that a conscious balancing of risks and advantages took place. So in the Keegan case, the court relied heavily on, that was the UDOT case. UDOT's had a comprehensive study and analysis and a departmental debate about its decision not to install a permanent median barrier. And it was contemporaneous with that decision-making process. So those minutes of meetings that describe who was there and what was discussed and debated, and the various types of considerations that went into those debates, such as, the risks, the balancing of financial impacts, the impact on the environment, how it would affect the community, those types of things, putting those in. And the documentation needs to be done contemporaneous with those decisions. Such documents that you might consider, as we've talked about, are maybe, in addition to minutes, they need to not only include the fact that it was discussed, but the debate that was had, so that the court can see there was this actual weighing of the factors. Budgetary spreadsheets are helpful, that show how the government has finite resources, and has to determine how to allocate which projects for it to go to. Materials considered as part of the decision-making process, such as reports from experts, such as design professionals, if it relates to, something that is considering being built, environmental studies that are done by people who have been employed or hired, not employed, but hired to analyze and present the entity with its recommendations. Correspondence in all forms, whether it's a letter or emails, notes placed in a file. And in many instances, it is probably worth following up on a department meeting with an email, in addition to minutes that are had summarizing what the points of discussion were, where there were areas of contention, items that were considered, and a decision reached. Just there's another layer of protection that can also apply. So in the spreadsheet, which you will have, it outlines some of those factors and those things that you can do to help. I don't want to say paper the file, because that makes it sound like we're trying to create something that doesn't exist, but create a trail of what actually did happen and exists.
Heather?
Yeah.
Roger made a point in here. He says, this is one reason resolution and ordinance recitals are so important.
Oh, Roger, that's a great point. Have you had any particular experience where you've been able to use that and found that it was helpful, or learned from an example of what could have improved to become more helpful?
Let's see.
Heather, I have not had the occasion to use those in the discretionary function context, but there have been many times when laying out the history and policy considerations have proved valuable.
And they're not just valuable in a litigation context either, are they, Roger? I mean, they are really valuable to help the public understand all of these factors that our cities and counties are, and our districts are weighing, so that they don't think we're just making these off the cuff, decisions that favor certain people or entities, right?
I agree with you on both the public aspect and the litigation aspect.
Thank you. Thank you so much for reminding us of that. I appreciate that. The third factor to remember is that the decision should be one that is guided by experts where possible. And I would include, council members to be experts in certain areas, because they have more information than, a department head does just in implementing something, or the public does. As the lawyers in the room are well aware, expert testimony is, and the admissibility of expert testimony is governed by whether something will be helpful to the jury. And it's based on specialized knowledge or training or expertise. And someone's experience in a particular area, even if they don't have a certificate on the wall or the letters behind their name, is enough to render someone an expert in an area. So when we talk about experts, we're talking about someone with that specialized knowledge and expertise and experience. In a case that the Utah Supreme Court ruled and found discretionary function immunity with respect to a different decision by UDOT. It was one that related to the placement of railroad crossings. The court emphasized, and I quote, that UDOT's surveillance team performs on-site inspections and weighs the numerous factors relating to crossing safety. And then further, that the team, quote, consists of transportation experts who exercise their collective judgment and expertise in making their evaluations of the relative dangerousness of railroad crossings in Utah, taking into consideration their physical characteristics and configuration, the volume and type of vehicular and train traffic, and other relevant factors. So that is the Supreme Court backing up what we just talked about, someone being qualified as an expert. In addition to formal reports and studies, documents that show that the entity consulted with experts might also include emails to employees in other departments, agencies or entities seeking outside expertise and guidance, and communications, letters, reports, emails with those experts. So that covers everything that I had, and I wanted to open it up to questions. And if you don't have questions, but you come up with something in the future, or you come up with a circumstance, please don't hesitate to contact me or any one of my fellow attorneys at Christensen and Martineau. And if we don't know the answer to the question right off the bat, we'll look into it and work through it with you and find it. That is what we are there to do. So thank you for your time. And with that, I'll open it up and see if anyone has any further questions.
Yeah, we do have some questions here, Heather. Just a reminder to everybody, if you could type your questions into the chat box, that'll make them easy for us to get to Heather here. I have a question from Dave Pitcher. Has there been any case law regarding derivative immunity for engineering firms, contractors, or other professionals providing input into the decision process for public entities making these discretionary decisions?
That's a good question, Dave. And I think I did not include that in the scope, but if I recall from maybe some case summaries that I've done, I don't want to misstate anything, but my gut reaction is that, if I recall correctly, the court ruled that they do not enjoy the same immunity. But if you need us to look at that and do a little bit of research into whether that has specifically applied, we would be happy to do so. Just reach out in an email to me and let me know. My gut reaction, no, is because there is such a hesitance to apply governmental immunity just to government entities. And unless a government entity is engaged in, they don't have the same type, the engineers or the experts wouldn't have the same type of public policy constraints on them in making recommendations to the entity. They would be reviewing things and making recommendations, but it's the entity that has to resolve that balancing of factors, which is why I think that probably wouldn't happen.
All right. Dave had a follow-up question as well on that, that you may have already covered. What about derivative immunity for tort caps on liability resulting from losses occurring as the result of construction of public works?
Yeah, I think the answer to that one is the same, is that they would not, the caps would not apply.
Okay. Let's see, Jeff would like to ask.
Let me just interrupt really quickly. Along those lines, one of the things though that is so important to do, that I know you guys do, but just something for us to remember to keep top of mind, is to ensure that when we do hire those independent entities to do these things and these projects, that we make sure we get an actual copy of insurance that policies that they have for the particular policies, an OSIP policy, for example, and that the governmental entity is named as an additional insured on that policy. That has really helped us in a lot of cases. So sorry, Jason, I interrupted.
No, you're great. Jeff asked the question, as defense counsel assigned to a defective sidewalk case, what would be their best scenario for documentation to make a discretionary function immunity argument?
Oh, that's a good question, Jeff. You know, I think what you would want to do is to start out at the council level, taking a look at, you know, what types of depths of variations are, you know, that are dangerous, and maybe you consult an expert, an engineering expert or a traffic expert and that kind of thing, and if they have some data that can help guide the decision about, you know, a half an inch ridge is really not very dangerous. There are accidents, trip and fall accidents, only so many percentages of the time, but when you've got one that's 1.5, and it exponentially increases. And so then we take that as a council and we look at, all right, we are going to direct now our public works department to focus their priorities, number one, on the depth of the ones that are a certain height, and focus the resources there in implementing it. So then you have that policy decision. So if the issue is raised, you know, you let this 1.5 inch lip, or let's say you let this half inch lip exist, you know, without grinding it down, but you just painted it to notify someone, then you can say, well, that was not just a decision that was implemented by a department head. It was made and created by the council with the help of these experts that determine what is the most dangerous, and that we use in determining how to most effectively allocate our funds.
Great. Jeff had a second scenario for us. He says, what would be the ideal scenario where an entity has a large water line that they know is failing, and they need to figure out how to budget for the replacement, but it will take years to come up with the funds?
That is a quandary that I think the city that I live in is faced with, as I noticed 3 barricades and over 3 sinkholes this morning while I was out walking my dog. And I'm sure that's exactly what they're facing. I think what the council would want to do is to determine, I would say first there needs to be a determination of the extent of what the problem is. So you have someone go down and scope the lines and figure out what the extent of the damages are and what is needed within the city. And then you have an expert maybe take a look at and assess the prospect of failure for different types of defects that we see. You know, is there a crack, or is there a hole, or is there a shift that, you know, could be happening? And then having the expert sort of advise the council what are the most important ones to focus on, and then as the council to talk about or to have a spreadsheet or minutes that talk about what the city budget is for the next 3 to 5 years. I don't know how far out that it's going to go, but I'd say 3 to 5 years would probably be best, 5 being the best if you can. Budgeting that out with projections of revenue and what expenses are, and showing, we need to have this done for the police department, and we need to have this done for public works, and we need to have this done for HR, and what types of concerns does all involved. And so that then again, there is documented that we are looking at all these various ways we would all love to make things the very best. And I'd like to buy a new car every year so that I never have to replace my brakes or worry, or tires. But that's just not financially realistic. And so I have to budget out, if I know my car is going to start failing over the next 3 years, I need to sort of budget out what I can make work. And I think the same sort of thing applies with that documentation.
Okay, thanks, Heather. Bert asks, how does this apply to staff members that are injured on the job due to a risky occupation? Does discretionary function immunity apply?
To bar their claims? Is that, I'm assuming that's the question.
Assuming that's what the question is.
Yeah, so I think it just goes back to, well, first of all, if it's an employee, I think the workers' compensation issues are going to apply very first. And so I'm not sure that we would ever make it to that discretionary function immunity. But if we did, I think the government would certainly argue if it fell under that immunity, they would have the ability to raise that defense.
Mm-hmm. But generally, that's going to be within the one resolution for that with workers' compensation.
Yes.
Great. It looks like that's all the questions that we have at this point. Can I ask you one more, Heather?
Please.
When I am involved in training, whatever it is, I learn this great new stuff. I always want something actionable at the end of it. What is it that people that have attended this session today can go and do today or start in motion today?
Oh, that's so good, because yeah, we have meetings where we talk about all sorts of good ideas, but what do we do to actually make a difference? And I think walking away from today, you could go back to your governing bodies, your councils or whatever they are, and put on the agenda that we need to come up with a plan as to how we are going to document how we spend our limited and precious resources, particularly right now where things are even tighter. Get that on the agenda and start working on that. And then once you get it on the agenda, make sure that it carries over to the next one as you continually, I'd have it be a recurring item on the agenda to talk about, so that it never slips far from mind. And certain projects will take center stage at certain times. And then definitely for your fiscal years, have that budgeting process and analysis done and scheduled for those meetings.
Great. And would it be a good idea to come up with a list of those functions that may fall into this discretionary function world? Because there are some things that don't matter, correct? I mean, there's some things that matter a lot more.
That's a great idea, Jason. And that would be to sit down and really look at the PowerPoint and take a look at what are things that are just those operational decisions, and those things that are the policy things, and then write a list down of what those policy decisions are, and then focus the energy on what those policy decisions are.
Awesome. Thank you so much, Heather. Appreciate this presentation today. I think that's been really eye-opening to many of us out in this world, and I'm sure it will spawn many other questions. And so please don't hesitate to discuss with Heather, with us here at the Trust. One person I forgot to bring up on here was if Jeff had anything to add from the claims side. of things at the trust. Jeff, anything? I think I opened up your mic, didn't I? My screen changed and I can't find Jeff now. I'm sorry.
Thank you, Jason. Can you hear me now?
Yep, got you now.
Okay. I appreciate that and so grateful for Heather and her participation with us today. I just want to say that we all recognize that we have capital improvement projects that are coming up. We have capital improvement items that are aging, whether it's sidewalks, streets, pipes, parks, buildings, all of those things. And so developing internally a process for prioritizing where your problems are and putting those forward for your council members or your board to make decisions on those goes a long way towards not only protecting the entity, but also identifying where your real problems are and organizing how you take care of them. And it goes a long way as far as CYA for you as managers of your public works, your water operation or whatever. So you're putting forward the problems that you have identified to protect you and to protect your community. So discretionary immunity, it can't be raised all the time, but when it can, it can be very powerful. And it really is just an example of good governance and management of your fiscal responsibilities. So thanks again, Heather. We really appreciate it.
Thank you.
Thanks, Jeff. Thanks everybody for attending today. We appreciate all of your attendance. If you have any questions, please don't hesitate to reach out to us and we'll wrap up the session now. Thanks, Heather.
Thank you.